All right guys, so a little bit different type of video we're gonna do today. We're gonna talk about the Texas 1-to-4 residential purchase contract, and I'm gonna walk you through this contract. If you're a new agent or if you're an experienced agent and you just haven't really studied this thing, we're gonna go over this pretty quickly, but I'm gonna explain some of the most important things that you need to know. Now, keep in mind, you need to know all of this, right? You have to learn these contracts in order to be effective at your job, which will make you successful. So I'm just gonna give you guys a brief overview of what this contract looks like, what are some of the highlights you need to be able to know and explain to your clients. My name is Jeremy Smith. This is living an epic life in real estate. And in order for you to live that epic life, you have to be successful. Epic life means that things are going great, right? You've got enough money in the bank, you've got as many closings as you want, you've got all the clients that you can handle, things are going good, you're running a successful business. To do that, you need to know these contract forms, so don't forget to subscribe to this channel, hit the bell. I'm gonna do more of these educational videos. If you have a particular form that you would like for me to explain, hit me up, comment below, however you want to, and I will get it explained for you. But for now, let's get right into this 1-to-4 family residential purchase contract for resale properties. All right guys, so this is a TREC form, and number one, we have parties to the contract. Obviously, you're gonna put buyers and sellers' full names. First name, last name are gonna go in there. Paragraph 2 is your property. You need to fill this out completely, lot, block, what edition are they in, what city are they in, what county are they in. And keep in mind guys, common sense needs to be applied here. If you're looking in rural areas, you may not have all this information. It just may not exist. It may be a completely different legal description. So be creative with it, get with the broker, make sure that you're doing the right thing, but it's okay to think outside the box. You're not gonna be able to check all these boxes all of the time. So paragraph B and C of paragraph 2 references improvements and accessories. And what all this means is that anything that's permanently installed and built in, and then it gives examples of what those may be. Those are called improvements and they're supposed to stay with the home. Then paragraph C references accessories. So those things that it describes are accessories, and those are also supposed to stay. How will you know if they're not staying? Well, a couple different ways. One, there's a section in the MLS for exclusions. So if the real estate agent that's listing the property knows that there's some things that are excluded, those items should be in the exclusions. You would put those here if you agree with them. Now, just because it's in the exclusions in the MLS doesn't mean that the buyer is not going to want to ask for those things to be included with the sale. If they are okay excluding the curtains or a specific ceiling fan or whatever was noted in the MLS, they would put them in the exclusions. You may submit an offer with nothing in exclusions, and then you may get a counter offer to add things to the exclusions, and then that's part of the negotiation process. But if it's not excluded and it's part of a improvement or accessory, then it is supposed to stay. So familiarize yourself with those lists of items. And paragraph 3 references the sales price. So line A is the buyer's down payment. And to make this simple, let's say that you have a buyer buying a $100,000 home. They're getting a VA loan. They're putting $0 down. Line A would read 0. Now, if they're buying that same $100,000 home and they're getting an FHA loan of 3.5% down, then that line will read $3,500, which is 3.5% of $100,000. If they're getting a conventional loan and they're putting any other amount down, let's just say it's $25,000, that number would go there. So line A represents the buyer's down payment on the home, not their earnest money. We'll get to that later. Paragraph B references how much they're financing. So if they're paying all cash for that $100,000 home, line A would read $100,000. But if it's not, let's say it's 10% down, so line A reads $10,000, then line B would read $90,000, and you would need to check the appropriate box, either third-party financing, loan assumption addendum, or seller's financing addendum, and then $90,000 goes in line B rather, and then line C is the total of line A and B. So $10,000 for down payment, $9,000 financing, $100,000 is the sales price. Paragraph 4 deals with leases. If there are any items on the property, whether they're fixtures or there's actually a lease involved where people are living in the home under the conditions of this lease, those items need to be turned over to the buyer. So be aware of that. Some common things we see are propane tanks, solar panels, security systems, maybe even water softeners, maybe, I don't know. Could be anything, but be familiar with this paragraph. You don't want to get your buyer into a contract down the road, find out there's some leases in there that the buyer doesn't want to take over, and then you have to get out of the deal, right? So make sure that you're asking the listing agent for it if they're not providing that readily for you. Paragraph 5 here talks about earnest money and termination option. So termination option is also referred to as the option period, and this dictates who's paying what in this paragraph. So you'll deliver the earnest money to, and then in that line, the escrow agent. What you don't want to put is your escrow agent's name here, right? I know it sounds weird, but if your escrow agent's name is John Doe, you don't just put John Doe there. You want to put the title company that they're with. So let's just say it's First American Title Company, John Doe. You could do that, but you just can't put John Doe. You could just put First American Title Company if you want, because they're the title company doing it. Let's say they fire John Doe and assign another escrow officer to that deal. That would still be fine, but you've got to put the name of the title company there. Put their address. Remember to be thorough on these documents, right? So put their address there. And then how much money they're putting in earnest money. So in this $100,000 example, let's say it's 1%, so they're gonna put $1,000. If it was $2,000, $3,000, whatever that number is, put it in that blank there. And then how much are they offering for the option fee? Just varies, right? Depending on the situation. It could be $100, $300, $500. That varies. Whatever it is, talk with your client, educate them about the option period, and put that number in there that reflects what they want. If they're gonna deliver additional money in escrow down the road, you would need to address that in paragraph 5A1. And then B is termination option, right? How long does this buyer have the unrestricted right to terminate? And then it goes through and explains that even if they have that right, they've got to submit this money within 3 days, and the option period ends on whatever date specified or however many days after the effective date of the contract at 5 p.m. Right, so make sure that you are educating your folks on that and having those conversations. Paragraph C there talks about what happens if they don't deliver the earnest money on time. And D talks about what happens if they don't deliver the option fee on time, right? Those are important. Time is of the essence when you have these contracts, guys. So make sure that you are educating your folks on those things. Paragraph 6 references the title policy. Who is paying for the title policy? Most of the time when there's a lender involved, matter of fact, all the times that I have seen, a title insurance policy is required. It is an insurance policy. It is regulated by the state, so the numbers are already predetermined. It's predetermined based off sales price. Paragraph number 6, you're just determining who is issuing the title policy. That is typically the title company that you have to deal with, and who's paying for it. Is the buyer paying for it? Is the seller paying for it? Are they splitting it? Like, this could happen a multitude of ways, so make sure that you're checking the appropriate boxes. If they're splitting it, it's okay to check both boxes that says buyer and seller are both paying for it. The title company is going to look at this, and these are their instructions. So you want them to be very clear and concise, and make sure that everybody's on the same page with that. Further down in paragraph 6A8, there's a couple options. 1 is will not be amended, 2 is will be amended. And what all of that means is there's an option to have an insurance rider that goes on the title policy to cover the survey. It's 5% of the policy. So if the policy is $100, it would be $5. And that's for an extra insured benefit of the title company covering the survey in case something was wrong with the property boundaries or something on the survey. They would address that, you would be insured for it. So scrolling on down to paragraph C on page 3 here, talks about the survey, right? You need to know this paragraph. You really do. You've got to be able to explain it and utilize this paragraph in your client's best interest. So paragraph C1 says within blank amount of days after the effective date, the seller is going to give a survey and a T47, right? So you determine what that number of days is. I usually put 2 or 3. And then in bold it says if the seller fails to furnish the existing survey or affidavit within the time prescribed, buyer shall obtain a new survey at the seller's expense no later than 3 days prior to closing. All right, so if they don't give you the survey and a T47, you can instruct the title company to order a new survey and the seller is going to pay for it. So be careful with that. And then it checks down here, it says if the existing survey or affidavit is not acceptable to the title company, then who's going to buy a new one? check buyer or seller. You can be strategic with that. If you've seen the survey and you understand what that is supposed to look like, how old it is and all that stuff, you can make a very strategic move on there that could put your client in an advantage position. Paragraph 2 says that the buyer is going to get the survey, they're going to pay for it, and then you can indicate how many days that's going to take for them to do that. And then paragraph 3 is also the same thing, but the sellers, right? How long are you going to give the sellers to provide a survey and all of that. Paragraph D references objections. So if your client wants to use the property for a specific purpose, maybe it's Airbnb, they want to operate a motor vehicle repair facility or a nursing home or some different use that they want to be able to make sure that they can do that. You can put that here where this line right after the word activity, and then give how many days the buyer has to terminate if they find out that they can't actually conduct that activity on the property. So paragraph E2 talks about the homeowners association. Is the house in a homeowners association or is it not? And then you've got this bold and underlined section that says you're obligated to pay assessments to the property owners association. The amount of the assessment is subject to change. Your failure to pay the assessment could result in enforcement of the association's lien on and the foreclosure of the property. And then down at the very bottom says if buyer is concerned about these matters, the TREC promulgated addendum for properties subject to mandatory membership in a property owners association should be used. We use it 100% of the time, right? So if there's an HOA, you're going to want to use that form. We're going to have a video on that if we don't already. So look through the channel so that you can find the video that describes that form for you. Okay, so paragraph E3 talks about tax districts, tidewaters, annexation, property located in certified service area of utility service provider, public improvements or PIDs, transfer fees, propane gas system, notice of water level fluctuations if your property is a waterfront property, and any required notices. So it says the following notices have been given or are attached to this contract, for example, MUD, WCID, PID notices, etc. So you've got to understand if the property that you're writing this offer on is in one of these districts. There's tax implications that come of that, and so there's disclosures that need to be made. So make sure that you're aware of those things. Paragraph 7 is probably one of the most important paragraphs that you're going to be able to explain to your clients and utilize to put your clients in a winning position. So 7A talks about access to the property, and what all this means is that the seller has to keep utilities on all through closing, and they've got to give you, the buyer, reasonable access to the property for you to do inspections, right? They can't deny your inspection. They've got to cooperate and allow for that stuff to happen. Paragraph B talks about the seller's disclosure notice. So there's 3 boxes that you can check here. 1, the buyer has received it, which most likely if the agent uploaded it to the MLS or emailed it to you directly before you submit the offer, that would be the appropriate box to check. If you didn't get it, or if you know these contracts very well and you're very savvy and cunning about your approach, you may check box 2, right? So understanding box 2 is very important for you as an agent. What this means is if the buyer has not received the notice, and they're going to give the seller a particular amount of days, maybe it's 3 days, maybe it's 4 days, whatever it is, after the effective date to deliver the seller's disclosures to the buyer. So if the buyer does not receive the notice, the buyer may terminate the contract at any time prior to the closing, and the earnest money will be refunded to the buyer. If the seller delivers a notice, buyer may terminate this contract for any reason within 7 days after buyer receives the notice, or prior to closing, whichever comes first, and they get their earnest money back. So if you're representing a buyer, and let's say you can only negotiate a 5-day option period, but then you know how to use this paragraph to your client's advantage, and you say, hey, we're gonna check box 2, we're gonna say 3 days. And let's say they give it to you on day 1. You still have 7 days after that, right? So although your option period is only 5 days, you have 7 days for this. So this is why it's important to know your contract so that you can get very good at what you do, represent your clients the best you possibly can, and create as many opportunities for them. It's gonna cause you a lot of wins. So make sure you understand that. Paragraph C there, lead-based paint disclosures if the property is built before 1978. Paragraph D talks about as is, another important one to be able to explain to your clients. What does it look like when you check box 1? If you check as is, does that mean that you can't ask for any repairs? Absolutely not. If you have an option period or you don't have an option period and you do an inspection, you can still ask for repairs. The option period is there to give you the unrestricted right. But again, if you are a savvy agent, you know your way around these contracts, you could still get them out and get their earnest money deposit back without an option period. It's possible. So you got to know how to do that. But the other option is right? The buyer accepts the property as provided. Seller at the seller's expense shall complete the following specific items or treatments. A lot of times you'll see homeowners say, hey, we're gonna replace the carpet, or we're getting a new roof, or something like that. You would put that here. If you walk into the house and there's a broken window that you see that's a deal breaker, or some sort of damage, or you want the house to be painted, anything you don't want to have to negotiate further down the road, you can address it here, and this is where it would go. So paragraph E talks about lender required repairs and treatments, what that looks like. Completion of repairs and treatments, how does that look? Like, who can do these repairs? The state of Texas says if the job being done requires you to have a license, then the seller has to have a licensed person do it. Some of the most common things are electrical work, plumbing work, HVAC work. There's probably some more that I'm not thinking of, but if the state requires you to have a license, seller has to hire a licensed person, unless buyer and seller agree otherwise. That is, that there is an option for that. But let's say the state doesn't require you to have a license. Let's say it's drywall. You don't have to have a license to do drywall. Well, they can't just hire anybody, right? They have to hire somebody who is professionally engaged in those activities, right? So they can't bring the plumber over to do the drywall work, or the electrician to do the drywall work, or the guy from Home Depot that they just met to do the drywall work, right? They've got to provide receipts for these things. And again, if you're a savvy agent, you'll be able to protect your buyers very well when it comes to these repairs. Paragraph 7G talks about environmental matters. 7H talks about the service contract. This is also referred to as a home warranty. Look at your home warranty pamphlets before you put a number here. You can get a credit and your buyer is undercovered. So let's say you get a credit for $500 for a home warranty, but your buyer wants the home warranty that covers everything, and it's $750. Well, now your buyer is going to bring another $250 to the table to get that home warranty, or you're going to pay it. So make sure that you're communicating with them. You're putting the appropriate amount of money here so that the buyers actually get what they want. Paragraph 8, if you are a broker or a sales agent and you are part of the transaction, meaning that you own more than 10% in ownership of this property, then you need to disclose that. Paragraph 8B talks about broker's fees. Paragraph 9 talks about closing. So that's going to be your closing date, and it gives all kinds of information on what happens with this closing date. One thing to know is that this is an on or before date. So if you put July 4th as your close date, but the buyers can close on July 1st and the seller can close on July 1st, you don't necessarily need to amend the contract to do that. You should. Best practice is that you would, but you don't have to, because this contract already says on or before. So let's talk about paragraph 10, possession, another important one. 2 ways to take possession, either at closing or according to a temporary residential lease for the seller. So you need to know what that looks like. It says consult your insurance agency prior to change of ownership and possession, because insurance coverage may be limited or terminated. The absence of a written lease or appropriate insurance coverage may expose the parties to economic loss. The absence of a written lease, important, right? So if your buyer is buying the home and the seller is going to stay in the home after closing, you must get that temporary residential lease in writing and check the appropriate box here so that everybody knows to look for that it exists. It's part of the contract. Paragraph B here talks about smart devices. Sellers got to turn over all of those passwords. They got to make sure that the buyer has access to all of the smart features in the home. Paragraph 11 is special provisions. Don't write anything there. Just don't do it. Unless you get an attorney to do it, just don't do it. There's probably a form to cover what you're going to do anyway. You can't be redundant, so there's already things in this contract that address whatever you're going to put in about doing a final walkthrough 3 days before and waste. Don't do it. It will get kicked back if you bring that to us. So paragraph 12, settlement and other expenses. If your client is going to ask for the seller to pay any of their closing costs, you would put that information here in 12A1B. So let's say they're asking for $10,000 in closing cost assistance. That's where you would put that. And then the rest of that paragraph describes how that money is allocated. Paragraph 13 lets everybody know that everything's prorated. HOA fees, taxes, all of that is prorated from January 1st through the closing, through your closing date. Paragraph 14 talks about casualty loss. We're in Texas, tornadoes, even fire could happen anywhere. But if the house gets significantly damaged because of something, this tells you how you operate. So that doesn't happen very much, but if it does, you better know it so that you can refer back to it. Paragraph 15 and 16 talk about default and mediation. Paragraph 17 addresses attorney fees. If one party takes the other party to court, the prevailing party can get their attorney fees paid by the other party. Paragraph 18 talks about escrow. So it says the escrow agent, who is your title company, is not a party to this contract. Talks about expenses. What happens if one party asks for or demands the release of the earnest money? This is important. If you get into a deal that gets terminated and one party is demanding the earnest money and the other party is also demanding the earnest money and one party's in the wrong, what happens if they don't release this and they're in the wrong, right? This paragraph talks about that, tells you what to expect, how much time they have to release it. And then paragraph D talks about damages. What happens if you wrongfully fail or refuse to sign a release? Within 7 days of receipt of the request, you'll be liable to the other party for damages, the earnest money, reasonable attorney fees, and all costs of suit. So be careful. Don't be spiteful. If you did something to lose the earnest money, you did something to lose it. Being a pain in the butt is not going to help you. All right, so paragraph 19 addresses representations. Paragraph 20 talks about federal taxes. And if the seller is a foreign person, right, that's important. You need to know that because there's tax implications for your client and there's more of a down payment required for your client if the seller is a foreign person. Paragraph 21, I'll be honest with you guys, I used to hate this paragraph. I never did it, but now I do because I understand why this is here. You have to put your client's information in here. I know it sucks, but you got to do it because this is how the title company is going to communicate with your client, right? Also, this is how the buyer or the seller, or whatever side that you're not on, can communicate with you and your client as well. Right? So just study this in my license renewal stuff. So it's important. Put your client's information there. And then with a copy to buyer's agent at whatever your email address is, put it there. Paragraph 22, another important one. Any additional addenda that's a part of the contract needs to be addressed right here in paragraph 22. So if they're getting a loan, third-party financing. If the seller is getting a temporary residential lease, seller's temporary residential lease. If there's a HOA, the HOA addendum. If there's addendum for reservation of oil and gas, put that there. Any other addendum. What doesn't need to go there are disclosures. A lot of times people put disclosure and that disclosure. That doesn't need to go in there. I guess you can if you want, but this is mainly for addenda that affects the contract, right? So be mindful of that. If your clients have attorneys, which I've never done a transaction where the clients had attorneys and had to put the attorney information in there, but if you find yourself in that situation, that's where you're gonna put that information. And then the clients are gonna sign. Don't forget, the person who puts information here in the executed section is the agent that gets the last initial and or signature on the document. So if you send it over, your clients have signed everything and the seller accepts it as you presented it, then the listing agent would be the one getting the last signatures on this because there's nothing to change. Now, if for some reason you submit it to them and they counter back and instead of writing a new document, y'all one line something and change it, and then the seller does all their signing and does all their initialing and sends it back to you, then you got to get your buyer's initials on the changes. You would be the one to execute that contract because you got the last initials on it. So whoever gets the last initials and or signature is the one to execute that document. Execution date is absolutely critical because all of your timelines, including your option period, stem from your execution date. Last page, broker information. Remember to be thorough. Put the other broker's information on here, put your information on here. If it's an intermediary, it all goes on the same side on the right-hand column. If it's not an intermediary, the agent representing the seller is not from your brokerage, everything for you goes on the left side and everything for them goes on the right. Be sure to put their supervisor's name and your supervisor's name. Be sure to put everybody's license numbers. Be very thorough. Fill out all the fields that need to be filled out, or it will get kicked back to you unless you are at a brokerage that doesn't care about you. If they don't care about you, they're not going to care about your forms either. They're just going to let you be exposed to all kinds of risk. If that's your situation, hit me up and we'll change that for you. You need somebody to have your back. So do the right thing. Get everything on here that needs to be on here. This last paragraph on this bottom page is there for disclosure purposes only, right? This is the commission section. Pursuant to a provision, separate agreement, such as an MLS offer or compensation or other agreement between brokers, listing broker has agreed to pay other broker a fee and whatever they're listed in the MLS, right? 2%, 3%, whatever's in MLS is gonna prevail. So if you put 0 here, or if you don't put anything at all, or you put the wrong thing, it doesn't matter. It says this disclosure is for informational purposes and does not change the previous agreement between brokers to pay or share a commission. The previous agreement more than likely is going to be the MLS offer. So one pro tip, screenshot that MLS offer. I have had agents try to change the commission on me because their buyers or their sellers didn't get the deal that they wanted to. We actually beat the heck out of them in negotiation and they had to pay a 3% commission. Agent tried to change it to 2%. But I had screenshots and we dealt with that and we got our 3%. So pro tip, before you put an offer, screenshot the MLS printout so that you know and everybody else knows what the commission being offered is. And then last page, this is your receipt page. The title company is going to give you receipts for the option fee, for the earnest money, and for receiving the contract. They're going to receipt this page, fill it out, send it back to you for your file. Make sure that you get that. So guys, that is the Texas 1 to 4 residential purchase contract explained as fast and as thorough as I possibly could. Now we could spend all day going through this stuff and all the ins and outs. This document is the most important tool that you have in your toolbox, because if you don't know it and you don't use it, you're not going to have closings in residential real estate. Now, if you're using farm and ranch or new construction or commercial stuff, that's different, right? But if you're focusing on residential real estate, you are going to need to learn this document. It is a tool. When used right, you will do very well. When used incorrectly or with a lack of knowledge, this can expose you and your client to a lot of risk. So be diligent, focus on learning this thing. I hope this video helped you out some. Subscribe to my channel. Guys, I need your help growing this thing. We're gonna put out more educational content for you, more tips for you to grow your business and learn these contract documents. Again, I'm Jeremy Smith. Living an epic life in real estate is my dream. I hope it's your dream too. I hope to be able to help get you there. See you on the next one. Peace.